As a barrister, are you completely comfortable with breaking the law?
We're not breaking the law, Kay. We are very confident that our measures that we've announced yesterday are in compliance with our international law obligations.
Well, the Home Secretary is so confident she's not breaking the law that she's actually inserted this on the face of the bill. European Convention on Human Rights. Secretary Suella Braverman has made the following statement under Section 19(1)(b) of the Human Rights Act 1998. I am unable to make a statement that, in my view, the provisions of the Illegal Migration Bill are compatible with the Convention rights, but the government nevertheless wishes the House to proceed with the bill.
We are very confident that our measures that we've announced yesterday are in compliance with our international law obligations.
So why does the face of the bill say that the Home Secretary is unable to assert the new law is compatible with Convention rights?
No government representative has said that we're breaking the law.
But the government has shown a willingness time and again to act unlawfully whenever it suits it. Remember its unlawful suspension of Parliament. And the government also has form on saying a bill doesn't break the law when it actually does. Remember the Internal Market Bill.
The Internal Market Bill breaks international law. That's the discussion that's carrying on at the moment. You're shaking your head.
No, it doesn't. No, it doesn't.
I would say to my honourable friend that yes, this does break international law in a very specific and limited way.
This is what the Prime Minister said about his bill at a press conference on March 7th.
We don't believe it is necessary to leave the ECHR. We believe that we're acting in compliance with it.
Well, again, if that's the case, why does the face of the bill specifically say the Home Secretary is unable to assert the new law is compatible with Convention rights? Presumably the government has taken legal advice on this. And if all that's not bad enough, in a letter to MPs dated 7th of March, the Home Secretary writes, "Our approach is robust and novel, which is why I've made a statement under Section 19(1)(b) of the Human Rights Act 1998. This does not mean that the provisions in the bill are incompatible with the Convention rights, only that there is a more 50% chance that they may not be." So despite telling viewers this,
we're not breaking the law.
She's telling MPs it's more likely than not the bill may not be compatible with Convention rights. The Home Secretary is clearly unable to make the usual declaration that the bill's provisions are compatible with the Human Rights Convention. Now, whatever Parliament enacts is law, but the Home Secretary's inability to make the normal human rights statement is an acknowledgement that the European Court of Human Rights may rule against the UK on any future challenge. And the UN Refugee Agency has said deporting asylum seekers without considering their claims amounts to a clear breach of international law. Now listen again to what the Home Secretary said.
We're not breaking the law.
And now listen to Barrister and King's Counsel Chris Daw.
It's completely unlawful in international law, and I can break it down for you in very straightforward terms. The Universal Declaration of Human Rights was passed in 1948. After the Second World War, it specifically provides that nations must allow refugees or asylum seekers to apply for asylum. That was followed up by the 1951 UN Convention on Refugees, which specifically states the following. Asylum seekers are not required to apply in the first country that they reach. They are entitled to apply in any country which is a signatory to the convention, and they are not required to arrive in that country by lawful or regular means. There is specific provision that asylum seekers are entitled to arrive by irregular means without documentation, because if you use any form of common sense, you'll realise that any genuine refugee is unlikely to have proper documentation, and therefore it's highly improbable that they will have any lawful route to apply to arrive in a country and then apply for asylum. They are, as I say, governed by the European Convention of Human Rights, which provides that anybody in the United Kingdom is protected by due process process of law, cannot be imprisoned without a fair trial or any legal process. And I'm afraid this legislation breaks every single one of those fundamental pieces of human rights legislation, international law. And the irony of that is that the United Kingdom was the founding signatory of every single one of those documents, and it was involved in the creation of all of those basic human rights, unsurprisingly, because the United Kingdom was also the country which sacrificed most and fought hardest against tyranny, against the tyranny of the majority, which of course led to the deprivation of basic human rights in Germany and has done so in other countries around the world. So the United Kingdom has been historically at the forefront of protecting basic human rights. It's unimaginable from a legal point of view that you could detain someone without trial, without access to a lawyer, without access to the courts, and then deport them. I mean, it's just abominable from a human rights perspective and from an international legal perspective. We, the United Kingdom, will become an international human rights pariah if this legislation passes, comes into force, and is enacted in the way that it is. There is absolutely nothing about 50-50. There's no 50-50 about this. It is 100% certain that this legislation breaches the European Convention on Human Rights, and perhaps more importantly, the Universal Declaration of Human Rights. We're going to breach that knowingly in this country. It's a disgrace, and the government knows it's unlawful, and they know, frankly, it's the only way they're going to get votes at the next election.
There's been no consultation on this, including with lawyers. And remember, the rule of law is undermined if the UK government takes the view that laws, international or domestic, can just be broken. And the Prime Minister shamelessly continues to call those working tirelessly every day to uphold the rule of law
Lefty lawyers, lefty lawyers, lefty lawyers.
In doing this, he's shamelessly jumping on a bandwagon previously used by former Prime Minister Boris Johnson and the former Home Secretary Priti Patel.
The lefty lawyers.
Lefty human rights lawyers.
And he does it despite Johnson and Patel having been warned using dangerous language like this could put the lives of lawyers and court staff at risk. Remember, these are just legal professionals upholding the rule of law and holding the government to account. Here's more from King's Counsel Chris Daw.
If this were to be passed into law, where does that leave the UK government?
Where it leaves the UK as a country and our nation is that the European Court of Human Rights will undoubtedly declare that this is unlawful, will, I suspect, issue injunctions to prevent people being deported under this legislation. And that will leave, and I suspect quite deliberately, that will leave the United Kingdom Parliament and government on a direct collision course with membership of the European Convention on Human Rights.
And remember, the Home Secretary has already made her views known on this.
We do need to leave the European Convention on Human Rights.
As I've said many times, the European Convention on Human Rights protects the right to a fair trial, freedom of assembly and expression, the right to participate in free elections, freedom of religion, freedom from discrimination, the right to privacy, freedom from torture and degrading treatment. Saying the UK should join Russia and Belarus as the only European countries outside the Human Rights Convention is just completely insane.